just go from one meal to the other. You get through eating, and you'd wash your mess kit, and you go stand in line. Boy, we only had 2 meals a day, and the bathrooms were big long lines going to the toilet facility. Unfortunately for the British, the men were all off fighting the war, so they were out around the world, and we were stationed near a munitions factory, and it had 10,000 women employed in this factory, and they had...
Good morning. I want to get right to it. I've got some information that I want to disseminate to you guys and allow you to process and decide whether or not you feel it's relevant to you and your situation, or if it's just strictly great information to have. Memorandum of Law with points of authority on sovereignty of the people in relation to government of the several compact de facto states and federal government. To whom these presents shall come, greetings, take notice that it is a well understood fact of American history that the most dynamic document that set the course of America is the Declaration of Independence. It is the document that disclosed the tyranny of English government. It expressed the elements of the rights of men within any society, and that all men are created equal. The Declaration of Independence stipulated the chain of authority within governments, and of the obvious fact that the people created the government, that it was the people who instituted government, and in so doing, the people secured these rights, and that government at every level derives their just powers from the consent of the governed. It also is a well-established fact that the people did not give up their power to government or governments. The Declaration of Independence created the sovereignty in the people. But the Declaration of Independence didn't create the sovereignty in the people, ladies and gentlemen. That sovereignty was bestowed upon us by the Heavenly Father, the Creator, who created all men equally and gave us dominion, okay? So the hierarchy goes God, man, government, corporations, okay? Individuals, partnerships, all that stuff falls underneath government. Government created those things. Government controls those things. But man controls government. Okay, so you are the government, and it's just a matter of whether or not you're going to enforce the rules, regulations, statutes, city ordinances, provisions against these people who are in these positions as our trustees, as our servants. We are the ones to blame. I keep saying it over and over and over again. We are the ones who were derelict in our duties, asleep at the wheel, and have allowed these people to essentially turn everything over 180 degrees through a manipulation of language and allowing them to indoctrinate us in the public fool system, okay? So the in regards to the Declaration of Independence created the sovereignty in the people. It didn't create the sovereignty in the people. It established what was already known, that our sovereignty came from the Heavenly Father. We exhibit sovereignty because we are still subservient to the Heavenly Father, and He is the only true sovereign, because He who creates is master, okay? Not in government. Therefore, the people are above the creature or creatures they created, government, and that those who work for in government or governments are public servants and have placed themselves in a subservient position to serve the people within their function, office, position, via their oath of office. In regards to the principles established in the Declaration of Independence and the subsequent constitutions written and created after it, and of the true sovereignty, a written constitution is not only the direct and basic expression of the sovereign will, it is also the absolute rule of action and decision for all departments or arid office of government with respect to all matters covered by it and proceeding after it. And it must control as it is written until it is changed by the authority which established it. which is us, we the people. For reference, see State ex rel. Crenshaw versus Joseph, 175 Alabama, 579 57 SO 942, and Schmidt versus F.W. Cook Brewing Company, 187 MD 623 120, and E19 3 ALR 270. Collins versus Martin, 209 PA 388 139 A 122. 55 ALR 311, and Travelers Insurance Co. versus Marshall, 124 Texas, 45 76 SW 2D 1007, 96 Air AO 802, State X RD Lemon versus Langley, 45 Washington 2D 82 273 P 2D 464. Now, for the remainder of these, I'm not going to actually read the rest of the cases, okay, because it's just too confusing and it takes away from the message being projected here. And take notice of the following cases and points. For when the revolution took place, the people of each state became themselves sovereign. Martin E.T. All versus the lessee of Waddell, and that was in 1342, 41 U.S., 16 PET 367. The state constitution is the supreme law written by the supreme power of the state, the people themselves. That's Local School 20 Ohio MISC 222 and 49 Ohio OPS 2D 143 250. The Constitution is the voice of the people speaking in their, and it must be heeded. When the Constitution speaks with reference to a particular matter, it must be given effect as the paramount law of the land. Sovereignty itself is, of course, not subject to law, for it is the author and source of the law. But in our system, while sovereign powers are delegated to the agencies of government, itself remains with the by whom and for whom all government exists and acts, and the law is the definition and limitation of power. Yick Woo, 118 U.S. 356. Under our system, the people who were there in England called are here their rights, whether collectively or individual, are not bound to give away to a sentiment of loyalty to the person of a monarch. The citizens here in America knows no person, however, in years to those in power, or however powerful himself, to whom he need yield the rights which the law secure to him. United States. I'm missing some key points here. Here in America, sovereignty rests with the people. That's Chisholm ex rel versus Georgia. That was a Dallas case. It is true that at English common law, the duty of an attorney general was to respect the king, he being the embodiment of the state. But under the democratic form of the government now prevailing, the people are king, so the Attorney General's first duty are to the sovereign rather than to the machinery of government. Hancock's versus Alcron. That was a Kentucky case. Kentucky Constitution, Section 4, Commonwealth ex rel. Hancock versus Paxton, Clause 3. Local laws or ordinances enacted by a city must be consistent with the state constitution. Bell versus Vaughn. That's a Florida case. And then Evans versus Berry, which is a New York case. It is the duty of all officials, whether legislative, judicial, executive, administrative, or ministerial, to so perform every official act as not to violate constitutional provisions. Montgomery versus State of Florida. The provisions of the Constitution must be given effect, even if, in doing so, a statute is held to be inoperative. State ex rel. West versus Florida. The Constitution was made not to act upon the legislative department alone, but upon every department of the government. Courts should not tolerate or condone disregard of law and arbitrary usurpation of power on the part of any officer, and neither should the people. That's an Oklahoma case. The officer of the law in the execution of process are obliged to know the requirements of the law, and if they mistaken them, whether through ignorance or design, and anyone is harmed by their error, they must respond in damages. Rooster versus United States, Rogers versus Conklin, and that's a U.S. case 644, 17 LED 714, emphasis added. It is a general rule that an officer, executive, administrative, or quasi-judicial, ministerial, or otherwise, who acts outside the scope of his jurisdiction and without authorization of the law, may thereby render him amendable to. If a public officer authorizes the doing of an act not within the scope of his authority, he will be held liable. That's a New York case. In our country, the people are sovereign, and the government cannot serve its relationship to the people. In common usage, the term person does not include the sovereign, and statutes employing it will ordinarily not be construed to do so. U.S. versus United Mine 330 U.S. 258 in 1947. Since in common usage, the term does not include a statute's not implying the phrases are ordinarily construed to exclude it. 1 U.S.C.S. 1 in 12 United States where rights secured by the Constitution are involved, there can be no rulemaking of legislation which would abrogate them. Miranda versus Arizona. The Congress cannot revoke the power of the United States. That was a 1935 case. There is no such thing as a power of inherent sovereignty in the government of the United States. In this country, sovereignty resides in the people, and Congress can exercise no power which they have not, by their Constitution, entrusted to it. All else is withheld. Juilliard versus the United States, 110 U.S. 42-1. All that government does and provides legitimately is in pursuit of its duty to provide protection for private rights, which duty is a debt owed to its creator, we the people, and the private disenfranchised individual, which debt and duty is never extinguished, nor discharged, and is perpetual. No matter what the government provides for us in manner of convenience and safety, the disenfranchised individual owes nothing to the government. I believe that's Hale versus Hinkle. Under our form of government, the legislator is not supreme. It is only one of the organs of that absolute sovereignty which resides in whole body of the people. Like other bodies of the government, it can only exercise such powers as have been delegated to it, and when it steps beyond that boundary, its acts are utterly void. We the people have discharged any debt which may be said to exist or be owed to the state or government. The governments are, however, indebted continually to the people, because the people, the sovereigns, created because we suffer its continued existence. The continued debt owed to the people is discharged only as it continues not to violate our private rights. And when government fails in its duties to provide protection, discharge its debt to the people, it is an abandonment, an injury of any and all power, authority, or vestige of sovereignty which is possessed, and the laws remain the same, the sovereignty reverting to the people whence it came. The individual may stand upon his constitutional rights, and that's a misnomer, because you don't have constitutional rights. You have God-given rights. The Constitution only draws a line in the sand. It doesn't provide you any rights. It's a piece of paper with some ink on it, okay? It's a free thought process that was scribed on the paper, and people said, oh, this makes sense. It's a good idea. So, please disregard the misnomer here of some piece of paper allegedly giving you rights, because it doesn't give you any rights. The individual may stand upon his rights, utilizing the Constitution as a tool of necessity to enforce his rights, okay, is a better way of putting it. He is entitled to carry on his private business in his own way. His power to contract is unlimited. That's Article 1, Section 10, and in Nebraska, Article 1, Section 16. And if you go through every 50-state constitution, you will find it there somewhere. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to investigation. That's Article 4, or the Fourth Amendment, excuse me. Not Article 4, Fourth Amendment, the right to be secure in your paper, person, houses, and effects, okay? He owes no duty to the state since he receives nothing from them beyond the protection of his life and property. His rights are such as existed by the law of the land, long antecedent to the organization of the state, which means it predated the constitutions. It predated the states. I mean, it goes all the way back to the beginning of time. And the beginning of time is not 1302. It's not the unum sanctum. It's not the creation of the trust. It goes all the way back to the Heavenly Father in the beginning, speaking the words, and he found that the words were with God and they were good. All right? So it goes all the way back to that beginning. His rights are as such as existed by the law of the land, long antecedent to the organization of the state, and can only be taken from him by due process of law, which is notice and opportunity, and in accordance with the Constitution. He owes nothing to the public as long as he does not trespass upon their rights. So without a victim, ladies and gentlemen, there can never be a crime. Although they masquerade around as enforcing the law, in most instances when they allege it's a criminal case, it's really civil in nature, but they can't produce the contract. Supreme Court, Hale versus, I want to say that's Hinkle again, but I could be sadly mistaken. The people or the sovereign are not bound by general words in statute restrictive of prerogative right, title, or interest, unless expressly named acts of limitation do not bind at the king nor the people. The people have been ceded all the rights of the king, the former sovereign. It is a maximum of the common law that when an act of parliament is made for the public good, the advancement of religion and justice, and to prevent injury and wrong, the king shall be bound by such an act, though not named. But when a statute in general and any prerogative rights, title, or interest would be divested or taken from the king or the people, in such case he shall not be bound. The Supreme Court, in the case of Wills versus State, made it perfectly clear that the cannot be named in statute as a or any person affiant am a member of the sovereignty as defined in Yik Wu. Sovereignty itself is, of course, not subject to law, for it is the author and the source of law. Yik Wu versus Wu Li and Wu Li versus the U.S. The law subscribes to the king in America, the people, the attribute of sovereignty. He is sovereign and independent within his own dominion and owes no kind of subjection to any other opponent upon earth. Hence, it is that no suit or action can be brought against the king, even in civil matters, because no court can have jurisdiction over him, for all jurisdiction implies supremacy of power. Chisholm. I'm not going to go into that. Chisholm versus the United States. People of a state are entitled to all rights which formerly belonged to the king by his prerogative. Now, something to think about here. Where did the king get his rights from? All right. when we start thinking about that, did the king just wake up one day and decide he had rights that others didn't have? Or was he more spiritually inclined and realized that the Heavenly Father bestowed him with rights, and then he chose to take a position, a seat of authority, and tell everybody else that he was going to lord over him, right? But that's why the founding fathers did what they did. They were tired of being lorded over by a lying, looting, pandering piece of shit who wasn't administering the grace of God as he should have been, who was so quickly corrupted by his source of power, and in doing so, the people revolted naturally. I mean, it's through the ages of time, it's been repeated over and over and over and over again. With limited power comes absolute grace. With complete power comes absolute corruption. People of the state are entitled to all rights which formerly belonged to the king by his prerogative. Well, I only know one king, and that's the Heavenly Father. And we're all entitled to those rights that have been bestowed upon us in a trust. And it's exhibited through the Lord's Prayer, as well as in Genesis. It's showing us our dominion, where we come from, that we're made in the image of the Heavenly Father in his likeness. We exhibit sovereignty, therefore. We can't be the true sovereign because at the same time, we're still subservient. It says in the Bible you can't serve two masters. So you have to pick. Are you going to serve man's creation, or are you going to serve the Heavenly Father and do what's right, just, and fair, and administer the grace of the Heavenly Father here on this earth? It's a conscious thing. It's about ascending of the mind, and it really is quite a feat to achieve that status in one's own mind. And the reason for that is our indoctrination, the vaccinations, all this junk that's forced into our bodies. I say that while I smoke a cigarette here. All these toxins and chemically laden horse crap that we ingest on a day-to-day basis is blocking our spiritual enlightenment. And that's why you might feel like you've plateaued spiritually. But I'm here to tell you, you can overcome that. In Europe, the executive is synonymous with the sovereign power of the state, where it is too commonly acquired by force or fraud or both. In America, however, the case is widely different. Our government is founded upon compact, which is a trust, ladies and gentlemen. It's an agreement. Sovereignty was and is in the people. Glass versus the Slope Bestie. That was a Dallas Supreme Court case. In the United States, the people are sovereign, and the government cannot serve its relationship to the people by taking away their citizenship. Note, the following definitions of sovereignty is from Bovier's 14th edition Law Dictionary, quoting from 4 Wheat 402. It has been a matter of to determine from what source the United States derives its. The question here proposed is whether our bond of union is a compact entered into by the states, or whether the Constitution is an organic law established by the people. To this we answer, we the people ordain and establish this Constitution. The government of the state had only delegated power from the people, and even if they had an inclination, they had no authority to transfer the authority of the sovereign people. The people in their capacity as sovereigns made and adopted the Constitution, and it binds the state governments without the state's consent. The United States as a whole, therefore, emanates from the people and not from the states, and the constitutions and laws of the states, whether made before or since the adoption of that Constitution of the United States, are subordinate to the United States Constitution and the laws made in pursuance of it. The people are the fountain of sovereignty. The whole was originally with them as their own. The state governments are but trustees acting under a derived authority and had no power to delegate what is not delegated to them. But the people, as the original fountain, might take away what they have lent and entrust to whom they please. They have the whole title and, as absolute proprietors, have the right of using or abusing justity, it's in Latin. It is a maximum consecrated in public law as well as common sense and the necessity of the case that a sovereign is answerable for his acts only to his God and his own conscience. There is no authority above a sovereign to which an appeal can be made. 4402 Bouvier's 14th edition Law Dictionary. Sovereignty. The Congress cannot revoke the sovereign power of the people to override their will as thus declared. The above points and authorities are not exhaustive, and additions can be added at any time. A sovereign is answerable only to God and conscience. Caveat that Derek Stawn Gonzalez, upon receipt of the Memorandum of Law on Sovereignty of the People with points of authority via certified mail, notice and demand is made upon you to review and respond to the above memorandum and each point and authorities as enumerated above and documented upon the public record by certified mail, U.S. mail, to the sovereign as addressed below, or to the notary's address as indicated below within 15 days upon receipt of this memorandum, allowing up to 3 days grace for return mail delivery. Failure to do so by as either a public servant who by oath of office or duty as an officer, agent, or employee of the government, created corporation, municipality, etc., and or by and through your position, office, or superior knowledge of the law, will place you in default. And the presumption will be taken upon the private and public record that you and your office fully agree or agrees to the points and authorities contained within the memorandum, and that the points and authorities are true, correct, and certain, not misleading, and that one of the we the people as named below and his/her seal signature is sovereign within the collective capacity of said we the people and possesses true sovereign power. Notice to principal is notice to agent. Notice to agent is notice to principal. Dated respectfully, and then it's got the date. But let's go a little bit further. Oh, yowzer. Boy, that's some old paperwork. I think I'm going to leave it there for now. It was just a nice little ditty, and I hope that helps you guys out a little bit. I could go through this other one, but I'm not going to at the moment. So thanks for joining me this morning. I've got some more hard-hitting information that I'll be bringing forward a little bit later this morning to you guys. So thanks for joining me. Be sure to share this with your friends and family. It's a season of enlightenment. It's time to wake up a little bit. And in closing, we're going to go through the 20 maxims of law. Rule of a maxim. Maximum of equity are not a rigid set of rules, but are rather general principles which can be deviated from in specific cases. Snell Equity and English trustees take the view that the maxims do not cover the whole ground, and moreover, they overlap. One maxim contains by implication what belongs to another. Indeed, it would not be difficult to reduce all under two. Equity will not suffer a wrong to be without a remedy, and equity acts on the person. Okay, so here we go. 20 maxims, real quick. List of maxims. 1. Equity sees that as done what ought to be done. 2. Equity will not suffer a wrong to be without a remedy. 3. Equity delights in equality. 4. One who seeks equity must do equity. 5. Equity aids the vigilant and not those who slumber on their rights. 6. Equity imputes an intention to fulfill an obligation. 7. Equity acts in personam or persons. 8. Equity arbors a forfeiture. 9. Equity does not require an idle gesture. 10. He who comes into equity must come with clean hands. 11. Equity delights to do justice and not by halves. 12. Equity will take jurisdiction to avoid a multiplicity of suits. 13. Equity follows the law. 14. Equity will not aid a volunteer. 15. Where equities are equal, the law will prevail. 16. Between equal equities, the first in order of time shall prevail. 17. Equity will not complete an imperfect gift. That's why you got to accept and acknowledge your warranty deed, ladies and gentlemen. 18. Equity will not allow a statute to be used as a cloak for fraud. 19. Equity will not allow a trust to fail for want of a trustee. And 20. Equity regards the beneficiary as the true owner. Thanks for joining me this beautiful Sunday morning, and we'll talk to you soon.